Welcome to today's program titled What Businesses Need to Know About the DOL's New FLSA Independent Contractor Rule. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. If we are unable to get to your question during the presentation, we will do our best to follow up with you after the program. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Andrew McKinley. Andrew, please go ahead.
Good afternoon. I'm Andrew McKinley, and I am a partner in Atlanta and Seyfarth's Atlanta office. I'm pleased to be joined today by what, in my view, is one of the best group of independent contractor experts I know, who I think are going to be able to provide a lot of information and value to you throughout today. We have Camille Olson, who is a partner based out of Seyfarth's Chicago office, with Eric Lloyd, a partner in Seyfarth's San Francisco office, and Kyle Winnick, an associate out of our New York office. Next slide, please. We're going to go through a few different stages of our discussion today to set up the historical landscape on independent contractor issues through the present day, and then eventually to what's next. So we'll start with the background definition of employee under the FLSA. We'll move on to the newly formed 2024 independent contractor rule. We'll jump into an in-depth discussion of the individual factors under the final rule, including questions that those factors and the DOL's discussion of them leave open. And then we'll touch on what's next, including potential challenges to the rule, legislative possibilities, and related issues that are of interest to the business community and the legal community. Next slide, please. All right, I'll hand it off to Kyle to start with the background discussion.
All right, thank you, Andrew. If you could please go to the next slide. So just by way of background, the Act itself does not provide a particularly helpful definition of employee. Employee is defined as an individual employed by an employer. An employer, in turn, is someone acting directly or indirectly in relation to an employee. And employ means to suffer or permit to work. So again, not particularly helpful. But that last phrase, to suffer or permit to work, has long been understood to capture more workers than the common law definition of employee. And next slide, please. But at the same time, the courts have long recognized that despite the broad definition of employee under the Act, it was not intended to stamp all persons as employees. And there are really two important cases on this point, and that's the case United States v. Silk and Rutherford Food Corp v. McComb, both of which were decided in 1947. The court framed the ultimate question of employee status as those who, as a matter of economic reality, are dependent upon the business to which they render service. And from these cases, the various courts of appeals generally use a six-factor test that takes into account the totality of the circumstances. And we list these 6 factors here. And while all courts of appeals use generally congruent frameworks, they do take different approaches. So, for example, some courts, such as the Fifth Circuit, believe the standard is really about dependence for income or wealth, as opposed to dependence on work within the pertinent field. So, for example, in a case called Parrish v. Premier Directional Drilling, a case that I was able to work on, oil field workers had multiple streams of income, which really had nothing to do with the work that they performed for the putative employer. So, for example, some plaintiffs ran their own goat farms. The court said that, well, this was probative of contractor status because they were less dependent on the defendant, precisely because they had multiple streams of income. Not all courts would agree with this approach. Rather, they would narrow the scope to whether or not you have streams of income within the relevant work being performed for the putative employer. The Second Circuit, for example, analyzes the opportunity for profit and loss and investment prongs. So those are the second and third prongs together as one factor. And this sort of makes sense, right? Because if you're investing in your business, you're doing it with an eye towards making a profit. And concerning the investment factor, while Silk seemed to focus solely on the investments made by the workers, some courts compare the relative investments between the putative employer and worker. This, of course, can lead to some absurd results because almost always the business's investments will dwarf the contractor's investments. So think about a solo attorney working for a much larger business. In the skill prong, some courts also consider an initiative, that is, on-the-job initiative such as managerial, while other courts use the term to ask whether the worker has really used his or her skill to obtain more jobs. Now, regarding this last factor, regarding the integral factor, in the Cone case, the integral prong really focused on whether the worker was part of a quote-unquote integrated unit of production, whether or not they were really working side by side with employees on production work. The integral prong, however, started to be viewed not as whether the worker was integrated into an assembly line, but rather, are the worker services quote-unquote critical or important to the putative employer's business? But of course, if a business engages a contractor, it's almost always going to be important, or else the business wouldn't have engaged in the contractor in the first place. I would go to the next slide, please. So just briefly, the Department of Labor never promulgated a generally applicable rule on contractor status until 2021. They did issue other guidances, which largely track the 6 factors that we just talked about. Notably, in July 2015, as sort of a precursor to the final rule, which we'll discuss in a few moments, the Wage and Hour did issue, it's called Interpretation Number 2015-1, which basically interpreted the traditional 6 factors in a way that heavily tilted the scales in favor of employee status. But this was later rescinded when President Trump assumed office. And if we could please turn to the next slide, please. Thanks. So this is a quote from an off-site opinion by Judge Easterbrook of the 7th Circuit, where he's listing some of the shortcomings of the economic realities test, namely that because it considers all the facts, it's hard to know how to weigh the probative value of any given fact. If we could turn to the next slide. And so, as a result, the case law has been conflicting. So, for example, cucumber pickers have been held to be both contractors and employees, even on similar fact patterns. And this is true even within the same circuit. So, for example, in the 5th Circuit, cable splicers who help repair down cable lines were found to be employees in one case, and then in the very next year, they were found to be contractors in another, even though it was the same defendant and more or less the same contract at issue. So all this is to say that applying the facts under the Silk framework has become challenging. And next slide, please. And so in 2021, the Department of Labor issued a rule on contractor status, and it did a number of things to help streamline the analysis. So first and foremost, it identified what it called 2 core factors, and those were control and the profit and loss prong. And within the profit and loss prong, they included investment, following what we discussed earlier about how the approach taken by the Second Circuit. And if these 2 factors, these 2 core factors, pointed one way, there was quote unquote a substantial likelihood that indicated the worker's correct classification. And while it's still considered the other 3 factors, these were less pertinent overall. And with respect to that 5th factor listed up there, it returned to the integrated unit of production standard under the Supreme Court's McComb case. And lastly, and I think this is perhaps most important, is that what the 2021 rule said was that the actual practice is more relevant than what may be contractually possible. So businesses sometimes in their contractor agreements will reserve the right to control the work performed by the contractor, such as inspecting the work or approving subcontractors and so forth. But at the end of the day, the business doesn't end up doing these things. So what the 2021 rule said was that in that scenario, the actual practice of not exercising control was more probative than what was written in the contract. And this sort of dovetailed with a related principle that courts often use, is that the contract is not controlling. And so just because the worker might have agreed within the contract that he or she was a contractor, that's not going to control the case. And so if that's true, though, then surely, actual practice is more important than what the contract says. And sort of, just to take a step back, what the 2021 rule did was it provided predictability. Now, if you have those 2 facts that point in one way, and they often do, you could be fairly certain about the classification of a worker. Now I'll turn it over to Camille.
Thanks so much, Kyle. Let's go to the next slide. So Kyle has just brought us through approximately 75 years of the history of independent contractor status under the Fair Labor Standards Act. So now we're up to January of 2021. In the next couple of minutes, I'm going to bring us through 3 years, January 2021 through January 2024. What happened? Kyle mentioned that it was in January of 2021, just before the end of the Trump administration, that the 2021 rule was published. It's published in January, and it was to be effective on March 8th of that year, approximately 60 days later. What happened is, because there was a change of administration, the new president had a short window of time in which he had the right to delay recently promulgated rules. And he did that. So on March 4th, after publishing its intent to delay the rule and a short notice and comment period, the Department of Labor delayed the rule that was published in January and to another 60 days, basically, until May 7th, 2021. And then before May 7th, within those 60 days, on May 5th, after a short notice and comment period, the Biden administration's Department of Labor withdrew the 2021 independent contractor rule before it was to take effect. So there were really 2 different, very sort of highly technical procedural rules and requirements under the Administrative Procedure Act that were followed or attempted to be followed by the Biden administration in terms of undoing that rule that Kyle just described. There were a lot of different issues that were raised with respect to the appropriateness under the Administrative Procedure Act of the Biden administration's actions in terms of, did it effectively first delay and then withdraw the rule? Did it comply with the Administrative Procedure Act in the various notice and comment period, the time limit of that period, and the reasons that were put forth for the attempt to withdraw that rule? And what happened was litigation ensued. So the Coalition for Workforce Innovation, shortly after the withdrawal of the rule, or the attempted withdrawal of the rule, filed a lawsuit in federal district court in Texas, claiming that both the delay and the withdrawal by the Biden administration was inappropriate in that it did not comply with the APA. And it didn't comply in that the amount of time it gave individuals and businesses to challenge or provide comments and notice was too short with respect to first the delay, and then secondly, with respect to the withdrawal, that it did not comply with the APA on a number of different bases, including because it didn't really effectively consider any alternative to just a complete withdrawal of the rule. So that was a lawsuit that was filed in Texas, on March, not in March, but shortly after the May withdrawal. What happened in that lawsuit is basically the complaint is filed, and then in effect, this is really a motion for summary judgment proceeding before that court as to whether or not the procedures were followed and the appropriate bases were raised. The motion for summary judgment was briefed, and in March of 2022, approximately 8 months later, the district court found that in fact, the Biden administration's attempt to delay and withdraw were both ineffective, and said that in fact, the 2021 independent contractor rule became effective on its original date of March 8th, and that it was going to continue to be in effect. Shortly thereafter, within 30 days, the Department of Labor filed an appeal to the Fifth Circuit of that summary judgment loss, invalidating its withdrawal of the 2021 rule. That happened in approximately April of 2022. And then for the next number of months, that case sat at the Fifth Circuit, and the Department of Labor requested that the Fifth Circuit put that case on hold or stay the case, because it in fact was working on its own independent contractor rule. And in fact, that case was stayed. And let's go to the next slide to see what happens after that. What we end up seeing is that, in fact, not in 2024, but actually just approximately 4 or 5 months later, in October of 2022, the Department of Labor came out with its proposed new independent contractor rule. It originally gave folks a short period of time to file comments that were ultimately extended till December 13th of 2022. So, you've got the independent contractor rule that was described by Kyle in place during this entire time. And the Department of Labor is actually supposed to be investigating and enforcing classification issues under that January 2021 rule that Kyle described. So the new rule is out, and it's in draft form, and a comment period begins in October and goes through December 13th. And then it's not for over another year. So what happens in 2023? There's a review by the Department of Labor of the over 50,000 comments that are filed by individual freelancers, businesses, organizations regarding that rule. And then the final rule ends up coming out in early January of 2024 with an effective date, which has not occurred yet, which is scheduled to be March 11th, just next month. In the Department of Labor's new rule, I'll call it the 2024 Independent Contractor Final Rule, it looks at the same test, which is applicable under the FLSA as the 2021 rule. Is the worker economically dependent on the person that it is providing services to, or is the worker in business for themselves? The shorthand is that is really described as the economic reality test. That is the test that has not changed over the years. And it's the test that the Supreme Court told us in those cases that Kyle cited was the test that would be applicable under the FLSA. But the difference here, what the Department of Labor did with respect to the 2024 rule is said, there are 6 factors, and these are the 6 that we are going to consider as relevant, and we are not going to give any additional weight to any particular factor. It depends on the circumstances. And in addition to those first 6 factors, which are set forth on this slide, we will also consider other additional factors that are relevant depending on the circumstances. And those aren't described in any detail. So basically, remember under the 2021 rule, we had 2 core factors that really would give you the answer. That many commentators said really what the Department of Labor did in that 2021 rule was really sort of figure out what have all the courts been doing and where do they come down in the end. And as Kyle said, look, they figured out that if you are an independent contractor, you show independence under those 2 core factors, you are more than likely going to be an independent contractor to this test. If you show the dependence, you're more than likely going to be an employee. And again, this is interpretive guidance of that economic realities rule. That's what these regulations are supposed to be. So the intent here was to provide guidance and clarity to both workers and businesses in these relationships. Here, the Department of Labor goes back and says, we're not going to give any particular weight to any factor, but these are the 6 factors that have been described, and there may be more. Let's go to the next slide. I've talked a little bit about this already. It rejected the 2021 rules focus on these 2 core factors. It also, in the 2021 rule, the Department of Labor said that the factor of investment is really part of the analysis of whether a worker has an opportunity to earn a profit or suffer a loss. Here, the Department of Labor said in the current rule that's been promulgated that no, that should be a standalone factor, and a little bit unclear whether it also will double dip and be relevant to the factor of opportunity to earn a profit or loss. I mentioned it considers other unnamed factors that'll be determined on a case-by-case basis. And besides that, sort of the framework that's different, what I would tell you, and I think is most important about the 2024 rule versus the 2021 rule, is that the 2024 rule interprets the facts that are going to be relevant to each of those 6 factors that are enumerated in ways that are very employee focused and often contrary to long-standing judicial precedent as to what those particular factors mean. Really putting the thumb on the scale that workers are going to be determined to be, more likely than not, employees versus independent contractors as to each of the individual facts. With that, I'm going to turn it over to my colleague Eric to talk about whether this is really just the ABC test that we all hear so much about. Eric?
Thanks, Camille. Let's go to the next slide, please. So to end the suspense, the final rule is not the ABC test. Little context here. One thing some companies were worried about was the possibility that the Department of Labor would adopt its own version of the ABC test for independent contractor classification. And that didn't come to pass, which those of us in states like California, where the ABC test applies, will tell you is a good thing. The ABC test turns on 3 different factors. First, the worker must be free from control and direction. Second, the worker must perform work outside the usual course of the hiring entity's business. And then finally, the worker must be customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed, Shorter version of that, do they have an independent business, and are they providing the same type of work to other clients that they are providing to the hiring entity in question? Biggest difference between the DOL's final rule and the ABC test is that each factor of the ABC test is dispositive. So in other words, if you don't satisfy each factor, then a contractor is going to be deemed an employee. The DOL's final rule, on the other hand, is situation dependent and takes more of a sliding scale, totality of the circumstances approach that doesn't turn on any single factor. With that said, there's a lot of overlap between the two tests. Both consider whether the hiring entity controls the worker, the extent to which the worker is integrated into the hiring entity's business, and whether the worker has taken steps to establish an independent business. So a lot of the same criteria that would be relevant in states where the ABC test applies is also going to be relevant when you're assessing contractor status under the new final rule. And just a quick point of clarification, because this often comes up with California having a number of exceptions to the ABC test. There are no exemptions from the final rule. The final rule sets forth the only tests that would apply to contractor classification, or the only factors, rather, that would apply to contractor classification. And I bring that up because California does have so many exemptions, and I want to make sure that everybody is aware that there is no similar exemption that the DOL has put forth in connection with the final rule. Next slide, please. Now we're going to dive into each of the factors set forth in the new rule. We can go to the next slide. So first up, let's talk about opportunity for profit or loss. And what the DOL said is the relevant inquiry here is whether the worker has opportunities for profit or loss based on their managerial skill. So what does that mean? Boiled down, this factor considers whether the worker can turn a profit or lose money based on how skilled of a business person they are. There was some consternation about this factor when the Department of Labor released its notice of proposed rulemaking a little while back. And under the NPRM, this factor turned in part on whether a worker actually took advantage of opportunities to turn a profit or incur a loss. And a lot of the folks in the business community said, well, wait a second, that doesn't make any sense. Because if a business person is truly independent, then they obviously have the discretion to take on or turn down work based on their business judgment. And the DOL heard that feedback and revised its guidance accordingly. So now what needs to be considered is whether the worker has opportunities and not whether they actually took advantage of those opportunities. Some of the considerations you'll want to keep in mind when mulling over this factor. First off, whether the worker determines or can meaningfully negotiate his or her pay. If the hiring entity is solely dictating pay, then that's going to cut against contractor status. Next up, whether the worker can accept or decline jobs or choose the order performance. And where the worker has discretion in these areas, that's going to support contractor status. Also, whether the worker engages in marketing, advertising, or other efforts to obtain work. And the theory here is that a legitimately independent operation will take steps to obtain more business from different clients, whereas a worker who doesn't do these things is more likely to be deemed an employee. Finally, whether the worker makes decisions to hire others, purchase materials and equipment, or rent space. A standalone business has to make these types of decisions and use business judgment in deciding the amount of investment that's appropriate into these sorts of things. And on the other hand, an employee typically would not decide such matters and wouldn't be concerned with their ROI on investments because they typically wouldn't have investments. The hiring entity would be making investments in an employee-employer relationship for the most part. One last thing to note about this factor, the DOL has made clear that working more simply that in and of itself does not weigh in favor of contractor status. So what's relevant here is not simply that the worker takes on every opportunity to earn a profit or a loss, it's whether they also exercise business judgment in doing so. Let's go to the next slide, please. The second factor we're going to look at is investments by the worker and the potential employer. And in a lot of the ways, this overlaps with the profit or loss factor I discussed just a moment ago, but it is a bit different. This factor considers whether investments made by a worker are capital or entrepreneurial in nature. And what does that mean? On the one hand, investments that go towards the running of a business may be considered entrepreneurial and supportive of contractor status. Some examples would be investments that enable the contractor to do more work, reduce the contractor's costs, or extend the contractor's market reach. Then on the other hand, tools and equipment that are required for a specific job rather than for general use. the cost of labor and costs imposed by the hiring entity would suggest employee status. The final rule also calls for a comparison of the worker's investments to the hiring entity's investments in its overall business. Important note, this comparison is intended to be qualitative and not quantitative. In other words, the inquiry will turn on whether the worker is making similar types of investments to the hiring entity, not whether the amounts invested, the dollar amounts, are similar to the hiring entity, which, 99% of the time, the hiring entity is going to invest quite a bit more than an independent contractor would in their business. So qualitative, not quantitative, is the important consideration to remember. And with that, I'm going to turn it back over to Kyle.
Thanks, Eric. Next slide, please. So I think in order to understand what the DOL did with this factor, I think it's important to look at how it was treated under the 2021 rule, which said that this factor would weigh in favor of contractor status if the work relationship is by design definite in duration or sporadic, and would point towards employee status if the work relationship is by design indefinite in duration or continuous. The 2021 rule did not analyze whether the relationship was exclusive, because that was part of the control factor. And it also said that this factor isn't always pertinent, right? Because it recognized that businesses value long-term relationships with contractors. Oftentimes contractors can provide more value precisely because they've been working with a particular business for a long time. The 2024 final rule takes a different approach. The DOL noted that this factor will favor employee status where there is a longer-term, continuous, or indefinite work relationship, and contractor status where the work is definite in duration, non-exclusive, project-based, or sporadic due to the worker being a business for themselves. But note how the department is really trying to tip the scales in favor of employee status, because on the one hand, they're saying longer-term work tends to show employee status, full stop. Then on the other hand, they're saying that shorter-term work is only going to show contractor status if the brief nature of the work was due to the worker being in business for themselves. In other words, longer-term work points to employee status, shorter-term work may point to contractor status. And this really conflicts with much of the case law. Lots of courts use as a benchmark, for example, if a worker has been working for a certain length of time, that may point towards either contractor status or employee status. And so whether or not it's longer or short-term under the case law does matter. The DOL had first proposed in its notice of proposed rulemaking that where a lack of permanence is due to operational characteristics, such as a seasonal job, that lack of permanence would not necessarily be evidence of contractor status. But of course, this is exactly the type of job where you would want a contractor precisely due to its short-term nature. In response to some comments, the final rule was adjusted to acknowledge that if the lack of permanence was both related to operational characteristics and the worker's exercise of independent business initiative, it may be evidence of contractor status. The final rule, however, provides no clear guidance as to what qualifies as a worker exercising his or her business initiative in this context. What the department seems to be saying is that if the worker, for example, had multiple potential short-term jobs, but for business reasons only chose one of those jobs, maybe that would point to contractor status. But of course, in this scenario, we would really be talking about the control or profit and loss prong. Next slide, please. So the department does provide a couple of examples, which in my opinion aren't that helpful. So essentially, a cook who has prepared meals for a venue continuously for years and hasn't worked for anyone else. This would favor employee status according to the department. In contrast, if the cook worked for the venue on a sporadic basis, but also worked for other venues, that would favor contractor status. But again, like you're seeing here how the 2024 IC rule is really blending facts from different prongs on the test, namely the right to turn down work or the right to work for other businesses. But that's really part of the control prong and or the profit and loss prong. So what the DOL really seems to be saying is that if a worker has a long-term relationship with the business is going to have to rely on other factors, such as control, to show contractor status. And with that, I will turn it over to Andrew.
All right, next slide, please. So as Kyle and Camille were discussing earlier, control was one of the factors that in the 2021 rule was considered a core factor. The DOL, again, determined that this factor should have no predetermined weight under this new rule. Now, I think anybody who litigates independent contractor issues with any frequency knows that a half or more of any order analyzing independent contractor factors is going to focus on control. It in fact is what makes a worker dependent or independent on the company. With a high level of control, the worker sure doesn't look like they're very independent. So there are some really meaningful changes here beyond the predetermined weight and the creation of ambiguity as to what how this should be weighed against everything else too. The new standard considers the potential employer's control, including reserve control, over the performance of the work and the economic aspects of the working relationship. It notes that the in the prior rule, the focus was on actual exercise. That wasn't to the total exclusion of what a contract could potentially allow, but it had an acknowledgement that what you actually do probably has a greater degree of relevance in the analysis. The new rule says, and the DOL's commentary to it says, we're not going to go that far. We're not willing to say that actual practice is always more relevant than what could happen. They also never say when what could happen could ever be equal to or greater in importance than what actually happens. They leave that for courts to sort out, which is obviously not particularly helpful to businesses and workers who are looking for clarity on what their relationships are. The DOL does seem to note that what contributes to control can be pretty exhaustive, but they identify 4 specific buckets of factors within the factor that they thought were worth particular discussion. One is scheduling, another is supervision, the third is rate setting, which is a lot like what we talked about before with the opportunity for profit or loss factor. And it also puts a focus on the ability to work for others. While the prior rule did specifically say that anything a company does to comply with the law, for quality control requirements, to meet contractual obligations, is not particularly relevant to the determination of whether a worker is an independent contractor or an employee. This rule seems to withdraw from that. It does stick to the idea that actions to comply with the law are not necessarily evidence of control, but it also says that those actions are not evidence of control if the sole purpose is compliance with the law. What does that mean? The DOL doesn't say very much about it. It's clear that if, for example, you do a training on what the law requires, but you also throw in, for example, extra legal business expectations as to safety, that probably qualifies as something going, as some additional purpose that could be problematic. But if that is inviting a look into a business's subjective opinions, that could become more problematic. Of course, most laws exist because there's some beneficial purpose to those laws existing. Their safety is one of them. OSHA requirements are there not just because the law requires it, they're there because businesses and workers benefit from those protections being in place. The focus here is also under this new rule solely on the employer's control, not the workers. The DOL says that that is consistent with years of judicial interpretation. It is interesting that they say that when the standard that Camille outlined at the beginning also says that you should look at whether a worker is in business for themselves. If you are only looking at what an employer does and not at everything the worker does, it does seem like you're cutting out a really substantial portion of a potential analysis of whether the worker is running a business for themselves. We'll jump to the next slide and we'll start going through the different subparts that this factor does look at. On scheduling, the new rule looks at whether the employer sets the work schedule. That is a shift. The prior rule looks at whether the business, the potential employer, was controlling the schedule. Now we just look at whether the employer is setting it. What does that mean? There's no guidance in the rule on that. I don't think it has ever been in dispute that if a business is telling a worker when to show up, where to show up with no choice, if they are telling the worker that there are consequences to not working at the times they want to, that's problematic from a control perspective. But I don't think that same standard has historically been the case. For example, if the worker has total freedom to say when they work and where they want to work, but the business takes an extra administrative step of memorializing that administratively in a schedule. It seems like this new standard could potentially put a business between a rock and a hard place where they have a choice of leaving the worker totally on their own and not having maybe an additional paper assurance of when they're going to show up. In which case they could put their commitments to their customers or their business prerogatives at risk. Or on the other hand, they could force that into a schedule, force assurances, and in which case they are increasing the likelihood of a misclassification finding. The rule does note that it notes that no scheduling freedom is definitely an indicator of employee status. Curiously, it's not willing to say that the converse is true. It says that scheduling freedom could be indicative of independent contractor status, but it isn't always. And it suggests that potentially limiting the numbers of hours available or sequencing to do the work or sequencing the work in a way that limits flexibility may be evidence of control. It's not really clear why that would be the case. And a lot of practical examples in our daily life indicate why that would be a potential concern in how we interact with workers. For example, if I were to engage a plumber to work at my house and fix a problem that I have, I'm probably going to tell them that they are able to come between noon and 5. But they're definitely not able to come into my house while I'm sleeping at night. That certainly limits the number of hours available for them to work. Is that really evidence of employment that is different than any regular independent contractor relationship? I'm not sure it is, but the DOL does not give much in the way of specific examples as to how this standard should be applied. And as I mentioned before, the DOL does confirm in its commentary that the ability to punish workers for exercising the flexibility in scheduling does cut against independent contractor status. I don't think that's controversial. I don't think that's a particularly new standard. The rule also, or the commentary to the rule also says that the power to decline work is not itself persuasive evidence of contractor status. What additional factors make that power to decline work compelling evidence? The rule doesn't specify. That's going to be, I'm sure, a subject of litigation, but it's also something that creates some ambiguity for businesses in the short term. Let's go to the next slide. Supervision is the next factor, or the next sub-factor in control. Here, the DOL asks to consider not whether supervision occurs, but whether businesses reserve a right to supervise or discipline. The DOL looks to whether businesses use technological means to supervise the performance of work. But one really important distinction that it makes is that the collection of data, for example, delivery data, other information like that, that may incidentally track what a worker does, but is for some purpose other than controlling the worker's behavior, is not necessarily the kind of technological supervision or technological tracking that is problematic under the rule. The DOL's commentary indicates that a lack of supervision by itself isn't indicative of independent contractor status when the nature of the work renders it unnecessary. That's an interesting standard too, because it does seem to ignore that independent contractors are often engaged because they are doing the type of work that a business doesn't inherently have somebody in place to supervise. And it ignores that certain business models have been defined and developed in a way that creates this level of independence precisely to avoid potential liability risks. It seems to punish that historical attempt to create independence and suggest that it really has no bearing on the analysis now. The DOL does also say that providing detailed instructions at the outset and electronic tools that maybe direct performance of work throughout the process may be problematic. I would think, while there aren't many examples of that, that could, for example, be pings on an app that try to control a behavior, other things that are trying, maybe not through a person, but through technology to change behavior. Let's go to the next slide. Rate setting is the next factor. This considers whether a business exerts control over prices or rates for services. And it asks whether there is an ability to meaningfully negotiate a rate. Now, what does that mean? Again, unclear. I think in many situations, there's really not an effort by the worker to negotiate. That doesn't mean they couldn't. It just means they didn't try. A contract is offered, it has a rate. Is there wiggle room? If it's signed, nobody knows. And I think that's going to be a real litigation risk. It's going to be a fact question in many instances, because how does the worker may have believed they had no ability to negotiate, and how you establish that they did is certainly going to be something that I think is difficult to prove. There is also a hard distinction to draw between the business setting a rate and a business negotiating for the best deal that they can get. Where that line will be drawn, again, will be determined through litigation. It also doesn't really clarify what, exerting control over the prices and rates mean. Does that mean that the worker has to be able to determine the ability to set the price for the particular job? Or should it be credited if the worker can pick and choose between jobs that are at different rates and may be most profitable to it? Again, unclear under the rule. Let's go to the next slide. Ability to work for others is the final discrete factor discussed here. It asks whether the business expressly limits the ability to work for others. It also says that you should look to whether the business places demands on the worker's time that do not allow for work for others. How does that factor play out when the choice to take on a lot of hours is the worker's choice, and the worker's choice is what results in them not having much time to work for others? Again, no guidance on that. No guidance on how different kinds of limitations on the ability to work for others should be weighed. It's clear that a wholesale bar on the ability to work for others is problematic. That is definitely what was talked about in the 2021 rule. But it's unclear how much weight would be given, for example, on a limitation to not be able to work for one direct competitor instead of the market at large. And I think we can go to the next slide. And I think I am handing that off to Kyle.
Thanks, Andrew. So with respect to this prong, under the 2021 rule, the department said that this factor would weigh in favor of an individual being an employee to the extent that his or her work is a component of the potential employer's integrated production process for a good or a service. So this really harkens back to the Supreme Court standard that we talked about before. So for example, let's say, let me take the example of a freelance writer. He or she is not integrated into a publication's production process. They don't, for example, edit or assign or determine the layout of an article. They don't determine what's front page news or not. So under the 2021 rule, this factor would likely point to contractor status with respect to the freelancer. But the final rule, the 2024 rule, returns to asking whether the services performed by the worker are quote unquote critical, necessary, or central to the employer's principal business. And if so, this favors employee status. And so using the freelancer as an example, again, this likely probably would favor employee status under the 2024 rule because, if you're a newspaper, it is necessary to have people write articles for you. And of course, the DOL does not really explain how to determine the defendant's principal business or what is critical, necessary, or central to it. And in a lot of ways, this is broader than the case law, which really focused on whether the work was so important that it's central to or at the heart of the potential employer's business, whereas it seems like the DOL is really focusing on whether or not the work is quote-unquote important. And in some respects, I think this is actually broader than prong B of the ABC test, which asks whether work takes place outside the usual course of the business of the company, as we were talking about before with Eric. So, for example, if you take payroll, and we'll talk about payroll on the next slide as well, but every company needs to process payroll. Most businesses, of course, use a third party, but it is nonetheless very important to every business. And it's generally outside of the usual course of the business of the company, unless, of course, they're a payroll processing company. But under this standard, again, it could be argued that processing payroll is important and critical to the business. If you go to the next slide, please. So the DOL provides a couple of examples. So one is a worker who works on a farm picking crops, and they've opined that doing so is a critical, necessary, or central task to the principal business of the farm. And then it contrasts this with an accountant providing non-payroll services, such as filing taxes, is not critical, necessary, or central. Note, though, and as we were talking about before, that the DOL is careful to say non-payroll accounting. The DOL might not necessarily be implying that all, that providing payroll accounting is always going to point to employee status on this prong, but they're definitely leaving the door open. And again, the DOL has a very broad interpretation of this factor. And with that, I will return it to Andrew.
All right, and I will wrap up the last two factors before we get to what's next. Let's go to the next slide. The next major factor, really the final of the delineated factors, is skill and initiative. This one's a little bit of a misnomer. The title suggests that skill and initiative are two separate considerations. In fact, the rule says that what you're supposed to look at is whether the worker has skills that contribute to business-like initiative. So, for example, if you are a highly certified professional, for example, a nurse, but you perform a job that requires none of those skills that required certification, then your skill may not have as much value than if you were a highly certified nurse who used those skills to find opportunities that use that apply the skills. That's not a totally surprising standard. I think that what maybe this standard does invite is consideration of skills that maybe go beyond the ones we typically think of, right? We think of education, we think of licenses, I think that it also invites consideration of things like people management, marketing, and information management, things that certainly people can bring to the table that add to maybe the more foundational aspect of a particular role that we typically think of. And let's jump to the next slide. Next slide again. All right, there's finally the additional factor consideration. Camille mentioned this above, but to the extent the DOL was searching for a rule that provided clarity, the inclusion of additional factors pretty much removed most of it. This set essentially provides that if whoever's analyzing the situation thinks that something else should be considered as evidence of independent contractor or employee status, it should be added to the mix. Businesses, workers aren't able to do a lot with that. They're going to be left guessing, and ultimately it's going to be in the discretion of a judge, the particular judge who's dealing with the issue, or the particular agency dealing with the issue, to determine which factors should be given weight, and if so, how much. And let's go to the next slide, and Camille will talk about what's next. I'll talk about CLE first.
At this time, we will read the CLE code for today's program. Please write this code down as it will not be reread. The CLE code for this webinar is SS, as in Seyfarth Shaw, 2576. Once again, the code is SS, as in Seyfarth Shaw, 2576.
Thank you so much. I recognize we just have a couple of minutes left, so I'm going to sort of go through this quite quickly. What's next? I think I can summarize it in really just a couple of comments. One is there will be many challenges on many different fronts to the 2024 rule. Second, there will be continued uncertainty in terms of both the importance, the relevancy, and the weight that's going to be given to that rule. Let's go through just a couple of those. The next slide. Court challenges to the rule. Where are we with that CWI lawsuit? And what I would say is there was quite a struggle in the Fifth Circuit once the new rule came out. The Department of Labor said, okay, nothing to see here anymore. This case ought to be just dismissed. Whereas CWI said, oh, no, no, no. This case was stayed, and it needs to now go back to that same district court in Texas that previously invalidated the department's actions to consider this new rule and any amended complaint that we want to file. The Fifth Circuit last week declared that the district court decision was moot and vacated it, and contrary to the Department of Labor's request, remanded the case back to that same district court that was previously very receptive to CWI's arguments for consideration of CWI's to come new amended complaint. Just this week, CWI filed a motion to expedite the issuance of the mandate from the Fifth Circuit to allow it to file that amended complaint before the effective date of the new rule. So one thing we're going to see is whether or not there is any attempt to delay or stay the effective date of that rule, which is coming up pretty soon. There's a second court challenge. It was filed very quickly after the final rule came out. It's been filed in Georgia, and it's been filed by 4 freelance writers and editors challenging the rule as arbitrary and capricious under both the APA as well as the Constitution. Next slide. What are courts going to do with the rule? It is not going to be applied retroactively because, again, given the litigation I described, the 2020 rule is currently effective. But what about the rule? What about after March 11th? If a court challenge is not effective in stopping it, does it become law on March 11th? And the answer to that is this is an interpretive rule. It is not binding on the courts, and it will be given some deference by some courts, but perhaps not by others. And I want everyone to also consider this in the context of just this term in January. The Supreme Court considered whether it would eliminate the narrow principle of Chevron deference to a federal court's reasonable interpretation of a law when a statute is ambiguous. That principle is going to impact challenges to the 2024 independent contractor rule. We're going to get a decision on that by July. We could get it earlier. As I mentioned, the case was argued in January. So we could be getting a decision in the two cases involved there involving federal agencies and whether their interpretations should be given deference, and if so, how much. We could be getting that any day. Next slide. What did the DOL say itself with respect to the impact of the final rule? And I'm looking here in terms of these first three bullets to the commentary that it published, which is voluminous. It's over 100 pages in connection with the final rule. And it basically said nothing to see here. There's really no change. Independent contractors play an important role in the economy. You know, the concerns about what this is going to do are not realistic. And this is the same standard that's always been applied. What's been the business community's reaction to the rule? Disappointment. That what has really been described by many, many different aspects of the business community as this is really a rule that undermines and is biased against independent work relationships at a time when there is such a worker shortage in our country. The business community, in terms of its own practices of businesses, are generally continuing their existing independent contractor relationships, but with a renewed vigilance in making sure that it complies with the economic realities factors, although not necessarily interpreted by the DOL in this rule per se. It's also recognizing that notwithstanding what we do in terms of the FLSA, that there are other considerations and other rules that are applicable and other exemptions that are applicable in other areas of law. And even with respect to the FLSA, what I would say is, as Eric said, there are no exemptions to the final rule, but in 213D to the FLSA, there are exemptions to the FLSA so that certain categories of workers are not subject, whether or not they're an employee or an independent contractor. So I encourage you to look there. Next slide. Here, legislatively, there are a lot of things on the horizon. First of all, you've got the NLRB issuing a new test for independent contractor status. You've got FTC commissioners who are stating that it believes that they believe that there are anti-competitive impacts of independent contractor classifications and misclassifications, and that the FTC should be able to reach those through Section 5 of the Sherman Act. So there's action there. Legislative proposals, the Worker Flexibility and Choice Act comes out of the House, as well as the PRO Act. Those are on different sides of the spectrum. The PRO Act really adopts the ABC test as set forth in California that Eric described. The Worker Flexibility and Choice Act really adopts the 2021 independent contractors test to amend both the FLSA and the NLRA. And then House Resolution 72 by Representative Issa is really just a resolution talking about the importance of independent contractors in the economic development and production of services in our country. I want to mention the GAO December 2023 report. It really criticized the underlying evidence and data on independent contractors that was used to support this 2024 rule, which comes from BLS study back in 2017, and says, look, all the federal agencies need to get together and figure out how to do this, how to accurately count, and also how to accurately describe the characteristics of independent contractors. And DOL and BLS have stated that they are going to take the lead in terms of that across agency effort. There is going to be, I predict, a potential Congressional Review Act resolution that may come out with respect to the final rule. One recently came out from the House with respect to the joint employer rule. And what does that really do? What it does is it's basically a joint resolution coming out of Congress, for both houses of Congress, that would have to be approved in effect by the president for it to negate this rule. That's unlikely, and President Biden has already said he would not sign or approve of such a disapproving resolution. But what it does, perhaps more importantly, it's not a silver bullet, but it provides weight to the argument, if it comes out of the House and the Senate, or one of those two branches, that the interpretations that the Department of Labor has provided in this rule are not the consensus of lawmakers in terms of what the FLSA and the independent contractor test was supposed to be. So that's important. I would also say there's been a number of different congressional oversight hearings with calling in both members of the public, freelancers, businesses, associations, as well as members of the Department of Labor, and also educators to discuss the impact. And I'm sure that there will be continued hearings on the issue of oversight over the Department of Labor and how it is intending to and how it is enforcing this rule going forward. With that, I'm a few minutes over. And I know I speak from all of us when I say we appreciate you listening to us. And if you have any more requests for information, please don't hesitate to contact any of us, and our contact information is here. Thanks, everyone.